Welcome to the McKinnon Legal Podcast, your guide to brighter paths beyond challenging marriages. Here's your host, Christina McKinnon.
Hello and welcome. We're into the end of the first week of November and the last 2 months of the year. 2024 is the advent of 2025 is upon us. Today, I have a wonderful guest. I've been trying to get her all year, you guys, to the listeners on this podcast, but I finally got her to agree and come and talk to us about a nuanced area of family law. And that is collaborative law. Her name is Kristen Goss. She is a very good colleague and friend of mine. After you try a couple of cases with a person and see how ethical and how determined they are and fighting the good fight for their clients and making sure that they're bringing value to the good people of South Florida, you consider them a friend. So welcome, Kristen.
Thank you so much, Christina. I appreciate you having me today. And I am so excited to see you and to be here. And likewise, always a pleasure. You're my mentor, one of my mentors. So
Wow.
I feel honored to be here. Yes.
Oh, okay. I didn't know I had that title. Hey, I'm out here passionately bringing value and hopefully helping a lot of people. And that's all it's about. It's not about anything else. But before I get into the substance of the matter, what we're here for today, can you tell the listeners a little bit about you and what you do and what your practice areas are?
Absolutely. So a little bit about me. I am a Florida native, born and raised in Fort Lauderdale. I attended the University of Miami, go Canes, for undergrad.
Okay, I'll forgive you for that one. All right.
I actually took a detour and went to Michigan. And so I attended the Thomas Cooley Law School in Michigan, Lansing, Michigan, out of all places. And so first time seeing snow in the Four Seasons, which was a great experience. But I came back home and I actually interned for the Miami-Dade State Attorney's Office at their domestic violence unit in the criminal division. Great training there, but knew I didn't want to do criminal defense or prosecute or any of that nature. And knew that I wanted to be a family lawyer from, I'd say, an early age. My mom was a social worker. My dad was a pastor, and I observed them helping families. And from very early on, I knew that I wanted to help families, but I'm also rules, policies, procedures type of person.
Yes.
So I like the law, and family law is what made sense. So
I think that's why we get each other. There's a way to do things.
Very much so. Very much so. My mom was a veteran, and so I have a lot of that structure. I need structure, organization, and I am fine with that. So that is that. And I also do estate planning and have been doing that for over 10 years, pretty much as long as I've been doing family law, and ended up getting into estate planning from personal experience, having to go through 2 years of probate litigation when my father passed away in 2014. So don't want any family to have to endure that. So it's very important to me to educate families on the importance of not only creating a legacy while they're living, but leaving a legacy for those they love most when they're no longer here.
Okay. So outside of family law, what inspired you to pursue this road and go on the trajectory towards collaborative law? What is collaborative law?
Great question. So it is not an adjective. Yes, it could be collaborative, but it is an actual statute that was passed in 2017 in Florida. And it's just a different way of doing things, similar to mediation, but in my opinion, it's a little bit more because I am a certified family mediator. When I'm a mediator, as I'm neutral, I'm not representing any side, so I have no say in anything. In the collaborative process, in order to qualify, you have an attorney representing each parent or each spouse. And all of the participants enter into a participation agreement that outlines the do's and the don'ts. We're going to be open and honest and transparent. That's very important. We're going to be committed to the process. We're going to be respectful of each other, even though we may not even can stand each other, but we are going to be committed to doing things differently with the help of our attorneys. Oftentimes we bring on other professionals, whether it's a mental health professional that normally facilitates the process and keeps emotions down as much as possible. You have the attorneys that focus on the legal side. You may bring in a forensic accountant that's also neutral. We're going over the assets and the debts. And it's just a different way of going through a divorce or a paternity or any type of family matter in a different way. It's more holistic. We're resolution focused. Nothing is filed in court until there's a full resolution. And then at the end, whatever is necessary. Oftentimes the financial affidavits are waived. Any financials are waived. So as when you're filing in court, things are public record. So
yes,
it's just a better way, if possible, for people to go through a divorce or any type of family action.
So you mentioned everything in a typical litigation case, whether it's a typical family case, paternity, child support, or divorce. In this instance, it is not public record. What happens? Are you filing this under seal?
So you are filing only a petition. It's usually a
Okay.
joint petition and a joint waiver and answer, and then the settlement agreement and the final judgment. That's it.
Okay, very well.
So it's
Go ahead.
So it can be under seal depending if the parties requested and if they qualify for it to be private. But I think the most is that there are no motions that are filed. There are no financial affidavits that are filed. There's no on the record request for reduction of documents, no interrogatories, none of that.
Okay. All right, very well. So what principles set collaborative law apart from just normal, contentious, high conflict divorce cases? And how can you have people foster that mutual respect and civility in collaborative law?
Very good question. So it is a work in progress, but I would say at the very end of the day, everybody that's involved in a collaborative setting, they are committed to it, including the professionals work together. We are more interest-based. So a lot of my mediation skills I will bring into the collaborative process. We're working together as a team. We're not positional. A lot of times the mental health professional will come in and play and say, hey, okay, Attorney Goss, you got to tone it down. But one of the main things I think that makes collaborative stand out from litigation is it is a client-led or client-driven process. So even though I can advocate for my client and say, this is what the law says, for the most part, of course, child support is something that can never be waived. But for the most part, we can come up with creative ways to resolve a matter that will likely not occur in a courtroom setting. For example, when it comes to alimony, that is something that we know now is no longer permanent. In a collaborative setting, they could say, we want it to be permanent. Not that happens. Saying that can be negotiated. And even though me as the attorney is the law says no more permanent alimony, if my client is really saying, in order to resolve this, I will do this. And this is what I want. And I know we crossed the T's, we dotted the I's. I know everything that the law says, but this is what I want to do. I have to be okay with that as my client's attorney.
And that the court will honor it. The court will certainly honor the party's agreement, even if it has to be reasonable, but outside of the strict construction of what the law says, right?
Yes.
Okay, so what happens if the parties aren't able to reach an agreement? Then what happens? Are you still in the collaborative law process? They've retained the mental health professional. They've retained the two attorneys on either side. They've retained the forensic accountant, and then it all blows up. Then what happens?
Yes, that's a great question too. So statistics and studies have shown over 85% of cases end in full resolution. With my personal experience with collaborative cases, I've had one case that has not resolved. And I would say it was because not all of the participants had the transparency piece in mind. They had ulterior motives. So in order for it to work, again, you're going to have to be committed. You're going to have to say, yes, I'm going to be transparent. There's one other thing I didn't mention earlier. to qualify, there is a disqualification clause, which is what your question centers around. So if in the event that the process breaks apart for whatever reason, the participants do have to fire their attorneys and take whatever issues that are unresolved to court. But there is a high percentage, over 85%, that do end in full resolution. And I would say at the very end of the day, commitment and being open and honest and transparent is key.
Right. But in that 15% of cases where resolutions and all the efforts towards having or maintaining that collaborative process and they break down, they have to retain a second set of attorneys. Is that what I hear you saying?
If they want attorneys, yes.
And okay. All right. And go through the adversarial process. Okay. All right. Very well. I just wanted to make that clear for our listeners because you've gone through a significant investment with the providers, mental health providers, the forensic accountants that were also retained in the process. And if you don't get this done, that there could potentially be another financial outlay to get all new attorneys on both sides to litigate.
Yes.
Right. Okay. All right. Very well. What are the common misconceptions that, hey, this is a simple process, so I want to do collaborative. Why is this not simple, or why is this not cheap?
Okay. So I will say this. In my opinion, of course, I think I'm probably a little biased. I do think it is cheaper than a litigation setting because the over 85% that do end in full resolution, you are only hiring one neutral facilitator with a mental health background. They're normally a psychologist or a mental health professional. If that were in litigation, oftentimes if there are mental issues that are involved, alcoholism, drug issues, any of that, normally you have each side that hires their own person to vouch for them, so that you have two people on the professional side in a mental health role that are particularly or can be retained in a litigated setting. The same with the forensic accountants. If it's in litigation, you're going to have one for each side. In collaboration, it's one that's neutral. They just present the facts. And that's it. Okay. But I actually forgot your question going on.
Why is it not simple, and why is it not cheaper than litigation?
So I would say it's not simple because you are actually getting down to the interest and the motivation behind someone having a position. You're having to not just deal with the emotions, not just hear the emotions, but understanding why and being able to resolve. For example, I always like to use this as an example. You have two people that say, I want the orange. So in a litigated setting, it'll be like, okay, my client wants the orange. They should have the orange because of X, Y, and Z. The other client would say, I want the orange. I need the orange because of X, Y, and Z. In a collaborative setting, it's okay, but why do you want the orange? What is it about the orange that is most important to you? And in a collaborative setting, you can find out oftentimes that the interest may be different. I want the orange because I want to make orange juice, one person can say, or I want the orange because I want to make something else with the orange, or take the outside and make something with the orange. So in that case, you can have the orange. Both sides could have the orange, but different pieces of the orange for different reasons.
So one wanted the peel, one wanted the flesh, and they both can have the orange. Gotcha. Yeah. I love that. I love that explanation. That analogy works for me. So I hope it helps our listeners as well. How do you address your clients' concerns about, I didn't win on this issue? Like, how do you manage the expectations? I know in an adversarial proceeding, what I deal with a lot of times in fighting to win on every issue or as many issues as I can in a divorce. But as you and I both know, as family law practitioners, there's no winning in divorce. There just isn't. But how do you address their concerns? How do you manage those expectations against them feeling like they've compromised too much?
It's really reiterating this: no one wins at the end of the day. And on one side, what are the pros with this? What are the cons with this? What are the future ramifications that can occur? Maybe having a neutral professional with a mental health background come in and help with that. But I think it's really trying to get them back to their interests, their goals, their concerns. Have your interests been addressed? Has your goal, like, even though you may have this particular goal and you're thinking you're going to get to it from point A and we get to it from point B, was it accomplished? Was your goal accomplished? Was your fears or concerns, were they addressed? I think it's having a conversation, reiterating, being empathetic, and at the end of the day, just letting them know and reminding them that no one wins at the end of the day. And what is looking at things as the glass half full opposed to half empty.
Okay. And what do you consider the hardest part of collaborative law?
Ooh, I would say the hardest part is deferring to the clients in certain settings. So in a litigated setting, there are deadlines that you have to comply with. In a collaborative setting, there's not necessarily deadlines. We have agendas. Okay, this is the date we're going to have a meeting, but there's homework that the clients also have to do. And if they don't do their homework or if it's half done, we can't really have a productive meeting in the collaborative setting. And there's no deadline to really say, okay, you got to turn this in by X date. It's really getting them to understand, hey, let's move in a sufficient, streamlined, matter. I think would be one of the hardest challenges. And I think also one of the hardest challenges is educating them about what collaborative really is. Because a lot of people say, I don't want to fight, I want to be collaborative, but are you willing to make those sacrifices? Are you willing to make those compromises? And it's hard, it's challenging because you're dealing with emotions and a trauma, divorce or any other family matter that makes it more complex. And then to top it all off, I've had cases where there are safety concerns. There's domestic violence involved, there's alcoholism. So you have layers and layers of things that you may have to unpack, and everyone has to be willing to do the work to be able to resolve. So.
Okay. And what is the average length of a collaborative case? So we know that most cases must resolve within, I think it's 18 months now, 12 months to 18 months here when I'm litigating. But what's your average time span? So when someone retains you and retains the professionals that are required, when could they expect? And I know it's all on a case by case basis, but on average, when could they expect to have that resolved?
So on average, the longest collaborative case I've had took 8 months. And that had everything in the kitchen sink: safety concerns, alcoholism, parents living in different parts of the state, and you name it. So that was the longest. The shortest amount of time it took was 30 days.
Wow. That is, even on your long spectrum, it is a short period of time, as you and I both know, in a highly contested adversarial litigated matter. So we talked about professionals such as financial planners, forensic accountants, child specialists, therapists. Is there a particular one that is required in every case, or do the clients get to decide what professionals they need?
That's a great question. There are no professionals other than the attorneys who represent one attorney for each parent or spouse. That's all that's required, nothing else. But if there are children issues that need to be addressed, oftentimes I would recommend a neutral therapist or mental health therapist to be the facilitator. Or if there's significant assets and debts that need to be divided, I would oftentimes recommend a forensic accountant. They're optional, but most often than not, at least a neutral facilitator is likely something that the parties would say, hey, we would want that person to assist us.
Okay. All right. And if you are speaking to a family law attorney or any attorney that wants to consider the collaborative law process, how would you advise them in terms of getting involved? Is there a certification process, or what would you advise them in terms of getting their feet wet in this area?
Absolutely. Reach out to me.
Oh, okay. And how do they do that, Ms. Goss?
You can reach me at kwglaw.net. You could also send me an email. My email is Kristen, Kristen, at kwglaw.net. But there are various local collaborative groups that are here in South Florida. There's a statewide Florida Academy of Collaborative Professionals. It's also international. So there's an International Academy of Collaborative Professionals. But yes, you do have to go through a training. It's not long at all, a 2-day training, and you will be collaboratively trained. But of course, there's ongoing learning. And if it's something in an area that you're passionate about, you're constantly around other professionals who are involved in the collaborative community. There's always like a scribe opportunity. So someone can come on and observe and take notes in a collaborative case if they're interested in having more experience and training. There are always advanced trainings and courses going on, annual conferences. Right. So there's a lot. Yeah.
Okay. Wonderful. Wonderful. Ms. Goss, I am so eternally grateful that you joined us finally after several months this year, me begging and pleading for you to come on the podcast. It was a lot of information that I didn't know as a family law practitioner with over 20 years of experience. I just don't delve into that area. I refer that out and, hey, I'm a fighter. I want to get into court and get my blood pumping. But at the end of the day, the work that you do is recognizable, it's certainly needed, and it is a viable option for people who have the resources and certainly want to amicably resolve their matters in this fashion. So thank you very much. Just one more time, I want you to put your information out there, and we look forward to having you in the new year again on our podcast.
Thank you. I appreciate it. And I have to get you on mine. So I wanted to mention that I do have a podcast. It's called Civility Wins, the Family Law Edition. It's on YouTube. So if you come across that, please subscribe, share. But you could reach out to me via email, Kristen at kwglaw.net. You could also look my website up. It's www.kwglaw.net. I'm on Instagram, kwglaw. I'm on LinkedIn, Kristen Goss, and Facebook, which is KWG Family Legal and Mediation Services. And thank you so much for this opportunity, Christine. I appreciate it.
Thank you for coming. And everyone, please have a great weekend. Enjoy the Veterans Day weekend that is coming up. We owe a great debt of gratitude to the people that have given us the freedom that we enjoy every single day. Once again, McKinnon Legal Podcast signing off for the second to last month of 2024. Thank you for the opportunity, and thank you for listening, and thank you for your support.
Thank you for joining us on the McKinnon Legal Podcast. Remember, there's always a path to a brighter, happier future. Stay tuned for more positive insights on troubled relationships and legal solutions. For more information, please visit mckinnon-legal.com. That's MCKINNON-legal.com. Or call 877-920-1614.